This is Nancy Leonard, Senior Partner at Leonard and Associates. Today we're going to talk about commercial leases and the legal concerns of franchisee tenants. So often I get the question of why use an experienced tenants lease attorney? Why is that important? And aren't the leases all boilerplate? And the answer to that question is hopefully going to be answered during this presentation, and that you'll see that they are very important documents, and no, it is not all boilerplate. Another question I get is, well, the franchisor's real estate team has negotiated the business terms. Why do I need an attorney? Well, you need an attorney to help you because of all of the other terms that we're going to talk about today, and even more than that. What we're going to discuss today is really the tip of the iceberg of the many, many, many kinds of clauses that are negotiated in a commercial lease. And lastly, people ask, what about having my spouse or friend or sibling who's an attorney handle this for me? And my answer to that is, unless they handle commercial real estate leases frequently, day in and day out, they're not going to know the many, many things that should be negotiated and how to negotiate those. So let's start with talking about the terms. Your local real estate agent has probably negotiated the rent, the base rent, which is also called minimum rent. And if there's percentage rent, they've probably also gotten involved in negotiating that. But in addition to that rent, you're probably also, if you're in a retail commercial space, going to be asked to pay your prorated share of the operating expenses of that shopping center, mall, strip center, or whatever. What's included or not included in those operating expenses is a gray area. We have an exhibit of 28 items that are to be excluded from those operating expenses. For example, depreciation or amortization of the center. Should that be included? We don't think so. What about legal fees related to leasing the center? Again, something we feel should be excluded. What about expenditures that the landlord has to make that are of a capital nature? Repaving the parking lot, or putting in handicap curb cuts, or whatever those might be. Again, something that we feel should not be spread out among all of the tenants. And lastly, my examples are, what about repairs that are caused by the landlord or by another tenant? Again, something that we don't think should really be the responsibility of all tenants. We like to see a cap on the expenses, and we want to see a right to review the landlord's books and records and be able to audit them if you feel that are errors in what you're being charged. If you're in the northern part of the country where there's snow, it's very unlikely that snow will be capped in any way. Snow removal is always unpredictable from year to year. So it's very unlikely that that's going to be something that'll be capped. It'll usually be an exclusion. But we have 28 items to exclude from those operating expenses that are passed through to you. Retail leases are typically triple net leases, which means that the landlord passes through to all the tenants on a prorated basis those expenses for the taxes, insurance, and operating expenses of the shopping center or mall. We just talked about operating expenses. What about taxes? What should be eliminated? For example, what about the taxes that are based on the income from the rents that the landlord received? Should those be passed through to you on a prorated basis? And what about taxes that the landlord had to pay on the sale or purchase of the center? Again, should that be put through to all of the tenants on a prorated basis? We don't think so, and those are a couple of the things that we try to negotiate to be changed. So let's talk about some practical issues, and let's start with maintenance. So typically the landlord's responsible for structural repairs. But what are structural repairs? For example, if you have a plumbing pipe that's coming into your premises, but it serves several premises or maybe the entire shopping center, is that a structural repair if there's damage to the pipe, or is that your responsibility because it's inside your premises? That's something that we would clarify. What about common areas? The landlord's typically responsible for maintaining those common areas, and that's part of what that CAM or common area maintenance charge that we talked about on the prior slide is for. And code compliance. Landlords usually responsible for making sure, certainly, that the shopping center, mall, and all common areas are compliant with the local codes. Tenants typically responsible for anything that relates to the premises itself. So that's interior plumbing, interior electrical, the plate glass for any windows and doors, non-structural repairs, and typically the HVAC system, which stands for heating, ventilation, and air conditioning. I always recommend that it's a good idea to have that HVAC system tested and checked out before you sign the lease to make sure that it is in good working order and has been maintained. To have it replaced if it's not, and get a new one with the warranty. And realize that it's probably your responsibility to maintain and eventually replace it if needed. And that's a very costly repair or replacement. So another issue that we encounter is the term. So often the real estate agent has negotiated a specific term, let's say 10 years. But when does that term begin? And that's important to know for renewal purposes, for one thing. For example, you may have a period of time in which the term hasn't really begun, where the lease isn't technically effective yet because you're in your build-out time. And so you really haven't, and maybe the lease isn't effective until you've opened for business, or maybe it's effective even sometime after that or sometime before that when the keys are turned over to you. Every lease situation is different. And so that's very important to get clarity on. And then, of course, there's also the question of when does rent commence? Because rent commencement could be, let's say, 130 days after you take possession. It could be 130 days after you open for business. And again, it's something that's negotiated, and so it needs to be clarified. What is the timing for notice for renewal? Well, it's really important to know when your lease commenced so that you know when your lease ends, when that 10 years, if it's a 10-year lease, is up. And you need to know when that notice for renewal is, because if that notice is 6 months prior to the termination, obviously you need to know those dates. You need to know how many options you'll have for renewal, and is the term consistent with the franchise term? That's pretty important, because if you have a 10-year franchise agreement and a 10-year lease, but your lease doesn't commence until some period of time after you take possession, you may have them inconsistent. And what happens then? How does that work out? Your franchise agreement's ended. You don't have a right to still operate the business in that location if you don't renew it. So what happens then? And what is the rent for renewal? I'm never a fan of fair market value at the time. I think it's a good idea to lock in that rent at today's rate. And that's something that should be negotiated with the realtor when you're negotiating those terms up front. What about assignment and subletting? What are your rights as a tenant slash franchisee to sell the business to either the franchisor or another franchisee? We like to see unconditional right to do that without any fees or costs involved. Franchisors' collateral assignment provisions, that's another important point. We like to see that those have been incorporated into the lease. You're required to do that. In most cases, most franchise systems have assignment requirements. And lastly, are you going to be released as a tenant and guarantor from any personal guarantee if you assign the lease under the sale of a business? So you definitely don't want to be out there guaranteeing the obligations of someone who bought your business, the financial obligations of someone who bought the business, or any other obligations. You certainly want to be released from that personal guarantee after the assignment has been finalized. So another issue that we often address is use. Is the use, meaning your right to use that location for whatever it is that you're planning on doing there, selling or servicing your brand, and whatever that entails. Is it broad enough to encompass everything that a franchisee will be selling? For example, if you're a fitness business, but you decide you want to sell t-shirts with the brand logo on it, or mugs with the brand logo on it, are you allowed to do that? Does the use section, is it broad enough to allow that? Another issue with use is exclusive use. And for example, you don't want another fitness business to be in the same shopping center as you if you can avoid that. So it's nice to negotiate an exclusive use provision in which, if the landlord leases to another similar type of business, that there's a penalty for the landlord for failure to comply. And that penalty is usually a reduction in rent, sometimes 50% or 75%, because it can greatly impact your sales. So you definitely want to have some penalty on the landlord for that. What about signs? Signs are critical. How do people find you if you don't have a sign up? And that sign needs to meet the requirements that the franchisor has provided to you. So I always recommend that you get landlord approval prior to signing the lease, so that you have landlord's approval of the signage that you're looking for, and know that that's not going to be a problem with your landlord. Governmental approval usually happens after you've signed, but I like to see a right to terminate the lease if you cannot get the governmental approval of your signage. And lastly, on this page, let's talk about permits. It's another issue like signage, that if you can't get them, or the cost is so high to obtain them within some period of time after applying, you should have the right to be able to terminate the lease, because you obviously can't continue to do a build out and open if you can't get the required permits. And next on this is the legal concerns, purely legal concerns. So what about hazardous substances? We like to see a representation and warranty from the landlord for hazardous substances on the premises and the shopping center. And we want to see an indemnification by the landlord for that. It can prevent you from being brought into a lawsuit that the federal government might bring if there are some issues with hazardous chemicals that are in the shopping center. We want to see a narrow indemnification given by the tenant. So we want to make sure that the tenant requirements for hazardous substances and any indemnification is narrowly given. We want to make sure that you have that indemnification from the landlord, because, as I said, the tenant can be held liable for a cleanup, a federal cleanup or a state cleanup, if there's no indemnification from the landlord. The other issue is Americans with Disability Act compliance, and we like to see a representation and warranty from the landlord for that as well, that both the shopping center and the premises are in compliance with Americans with Disability Act. And that's really important, because if somebody can't get in to visit your location, who's in a wheelchair because there may not be enough handicap parking spaces, or the handicap curb cut is too sharp so that they can't get up that ramp, they're going to sue everybody, and you're going to be included. And if you have some sort of indemnification, or a minimum representation and warranty from the landlord, this will help with any lawsuit that might be brought against you by that person. Next, we're going to talk about default and remedies. And so it's very important, if you are in default, meaning you've breached your contract, that you have plenty of notice and opportunity to cure that default. Typically, there's a different notice period for a monetary default versus a non-monetary default. So typically for a monetary default, it's going to be a very short period of time, 5 days, 10 days is really probably as much as you'll ever get. For a non-monetary default, such as you have a crack in one of the plate glass windows, let's say, that they want you to repair or replace, that might be a 30-day notice that you'd be provided. What are the landlord's remedies if you do breach the contract? Well, they have a right often to terminate the lease and accelerate rent. And what does that mean? That means that they can charge you for all the remaining rent for the rest of the term of the lease. So if it's a 10-year lease and you breach it in year 3, they could charge you for 7 years of rent right then and there. They also could, under some leases, accelerate the rent without terminating it, meaning they could still hold you liable for all of the other obligations under the lease, and yet accelerate rent and make you pay that remaining 7 years in my example. They might be able to remove your property or sell off the personal property if they have a security interest on the property. So these are all kinds of things that we negotiate, because we want to make sure that you're in a much stronger position if there is some sort of breach that happens. Some miscellaneous things that we get involved with. What are the remedies on the landlord's default? What if the landlord has an obligation to maintain the roof and you have a leak in your store that is causing you to not be able to have the business? Let's say you have a massage business or a fitness business and there's a serious leak in the roof that's causing flooding in your store or that's caused damage. Do you have a right to stop paying rent? Do you have a right to terminate your lease? What are your rights against the landlord if they don't fix that in a normal, reasonable amount of time? What about personal guarantees that you're going to have to give the landlord, because most landlords today do require a personal guarantee? What kind of limitations can we negotiate for you? There are many, many ways to limit those personal guarantees. And what do those limitations mean? They don't always mean what you think they do. What about a release on assignment? We talked about that when we talked about the assignment clauses. You don't want to be involved in guaranteeing a lease that you've assigned to a buyer of your business, for example. And are all the business terms of the letter of intent included in the lease? So, for example, many times we see that a letter of intent has been heavily negotiated by the business people. And then when the lease is drawn up by the landlord's attorney neglects to put some clauses in that are from the letter of intent that are favorable to the tenant. So we always check that everything that's been negotiated in the letter of intent is actually included in the lease. Insurance, is it reasonable? If they're requiring $2 million of liability insurance, is that reasonable? What about $10 million of liability insurance? So that's something that we check, and we always ask you to have your insurance agent go through as well. Alterations, can the franchisee freely make changes that the franchisor requires? For example, you've had the store for 5 years. Your franchisor is saying, okay, you need to do a refresh of the look. We've changed some of the colors, we've changed some of the equipment, and you need to update all of that, new rugs, new paint, new whatever. Can you freely do that? Or do you need to go back to the landlord and get their consent? So in conclusion, I hope you've realized that leases are not boilerplate. Legal review uncovers many issues and concerns that business negotiations won't, and can ultimately save the tenant time and money. So hopefully, just as I said, what I've gone through today is truly the tip of the iceberg of the many, many, many things that we are negotiating. An experienced attorney understands which issues are important and ways to negotiate them. And we charge a flat fee for a commercial lease review. That fee hasn't changed in quite a number of years. So we are nationwide commercial lease attorneys. I'd love to hear from you, so please feel free to contact me. Again, this is Nancy Leonard. I'm senior partner at Leonard and Associates. My phone number is 215-392-0030. My extension is 101. And my email and website are up there. We look forward to hearing from you, and hope you enjoyed the presentation and have a great day.